Breaking news that could reshape the future of gun laws in America. A federal court has just struck down a major magazine ban, calling it unconstitutional. That ruling could affect gun laws across multiple states. And now, the issue may be heading straight to the Supreme Court of the United States. In several U.S. states, lawmakers have passed regulations that limit the size of firearm magazines that civilians can legally own. These laws usually define a large capacity or high capacity magazine as any magazine capable of holding more than 10 rounds of ammunition. Under these restrictions, gun owners may still legally possess firearms, but the magazines used with those firearms must be limited to 10 rounds or fewer. Supporters of these policies argue that limiting magazine capacity can reduce the potential harm during violent incidents by forcing a shooter to reload more frequently. They believe this could create opportunities for victims to escape or for law enforcement to intervene. Opponents of these restrictions, however, argue that the laws unfairly restrict lawful gun owners and violate constitutional protections. They claim that magazines holding more than 10 rounds are standard equipment for many commonly owned firearms, including popular handguns and rifles used for self-defense, sport shooting, and other lawful purposes. Because these magazines are widely owned across the United States, critics say banning them effectively limits the normal operation of firearms that millions of Americans legally possess. In the recent case drawing national attention, a federal judge examined whether such a restriction could stand under the protections of the Second Amendment. The court determined that magazines capable of holding more than 10 rounds are widely possessed for lawful purposes and therefore fall within the types of arms-related equipment that Americans commonly use. Based on that reasoning, the judge concluded that banning them could conflict with constitutional protections for keeping and bearing arms. The ruling does not automatically eliminate all similar laws nationwide, but it represents a significant legal challenge to magazine capacity limits. It also adds momentum to a growing national debate about how far governments can go in regulating firearm equipment while still respecting constitutional rights recognized by the Second Amendment. The court's decision relied heavily on a major legal framework established by the U.S. Supreme Court in the landmark case New York State Rifle and Pistol Association v. Bruin. In that 2022 ruling, the court introduced a new standard for evaluating whether firearm regulations are constitutional. Before this decision, many courts used a balancing approach that weighed government interests, such as public safety, against an individual's right to keep and bear arms. Judges often asked whether a law reasonably served an important government objective while only minimally restricting constitutional rights. However, the ruling in New York State Rifle and Pistol Association v. Bruin changed that method significantly. The Supreme Court stated that courts should no longer rely on that balancing test when reviewing gun laws. Instead, judges must look at the historical tradition of firearm regulation in the United States. Under this approach, the government must demonstrate that a modern firearm restriction is consistent with regulations that existed during the early periods of American history, particularly around the time the Constitution and the Bill of Rights were adopted. Applying this framework, the judge in the recent magazine ban case examined whether historical laws existed that limited the capacity of firearm magazines or imposed similar restrictions on commonly used firearm components. After reviewing historical records and previous legal examples, the court concluded that there was little evidence of comparable regulations from the relevant historical periods. Because of that lack of historical precedent, the court determined that the magazine restriction did not align with the constitutional standard described in New York State Rifle and Pistol Association v. Bruin. As a result, the judge concluded that banning magazines capable of holding more than 10 rounds could not be justified under the historical tradition test. This reasoning has become central in many recent legal challenges involving the Second Amendment and continues to shape how courts across the country evaluate modern firearm regulations. For gun owners, the ruling could have significant practical effects, especially in the state where the decision was issued. Magazine capacity limits often prevent individuals from purchasing or possessing magazines that hold more than 10 rounds of ammunition. If a court declares such restrictions unconstitutional, those limits could be suspended or removed, at least temporarily. This means that firearm owners in that jurisdiction may once again be able to buy, sell, or possess magazines that exceed the previously allowed capacity. Many modern firearms are designed to use magazines that hold more than 10 rounds. Because of this, Gun rights advocates argue that these magazines represent standard equipment rather than specialized or unusual accessories. They claim that restricting them interferes with the normal function of commonly owned firearms. From this perspective, a court ruling that invalidates a magazine ban could restore access to equipment that millions of gun owners across the United States already possess for lawful activities such as self-defense, recreational shooting, and competitive sports. However, the legal impact of the decision may not be immediate or permanent. When a lower federal court strikes down a law, state officials often respond by filing an appeal. During the appeals process, a higher court may temporarily pause the lower court's ruling while the case is reviewed. This means the legal status of magazine capacity limits could remain uncertain until the appellate courts issue their own decisions. Because similar legal challenges are occurring in different states, the outcome of one case may influence others. Courts are increasingly being asked to evaluate these laws using the constitutional principles tied to the Second Amendment. If higher courts agree with the reasoning of the lower court, it could encourage additional challenges to similar laws. On the other hand, if appellate courts reverse the decision, magazine restrictions may remain in place. For now, the ruling mainly signals that the broader legal debate over firearm regulations in the United States is continuing to evolve. The possibility that this case could reach the Supreme Court of the United States is one of the main reasons it has drawn national attention. When federal courts review constitutional questions, their rulings usually apply only within their specific jurisdictions. However, when different courts interpret the same constitutional issue in different ways, it can create legal confusion across the country. In situations like that, the Supreme Court is often asked to step in and provide a final, nationwide interpretation of the law. Magazine capacity limits exist in several states, including places like California, New York, and New Jersey. Each of these states has adopted laws that restrict the number of rounds a firearm magazine can hold. As legal challenges move through the federal court system, judges in different regions may reach different conclusions about whether those laws comply with the protections of the Second Amendment. Some courts might determine that the bans are constitutional, while others might rule that they violate the right to keep and bear arms. When courts issue conflicting decisions on the same constitutional question, it creates what is often called a circuit split. A circuit split means that the law is applied differently depending on where someone lives. In those situations, the Supreme Court frequently agrees to hear the case to resolve the disagreement and create a single national standard. Because magazine bans are currently being challenged in multiple courts, legal experts believe the issue could eventually reach the highest court in the country. If the Supreme Court of the United States decides to review the issue, the justices would examine arguments from both sides, analyze historical legal precedents, and determine whether such restrictions align with constitutional protections. Their final decision would apply across the entire United States and could permanently define how courts evaluate magazine capacity limits under the Second Amendment. The legal debate surrounding magazine capacity limits is part of a much broader national discussion about the meaning and limits of the Second Amendment. While the amendment clearly protects the right of Americans to keep and bear arms, courts have spent many years determining exactly how far that protection extends and what kinds of firearm regulations governments are allowed to impose. Over time, several major court decisions have shaped how judges interpret this constitutional right. One of the most influential cases in modern Second Amendment law was District of Columbia v. Heller, decided in 2008 by the Supreme Court of the United States. In that decision, the court ruled that the Second Amendment protects an individual's right to possess a firearm for lawful purposes such as self-defense, particularly within the home. This ruling was significant because it clarified that the amendment applies to individuals rather than only to organized militias, which had been a major point of debate in earlier legal interpretations. However, the court also indicated that the right is not unlimited. Governments may still impose certain regulations, such as restrictions on firearms in sensitive locations or rules preventing certain categories of individuals from possessing weapons. Since that ruling, courts across the United States have been working to determine which types of regulations are permissible and which ones cross the constitutional line. Magazine capacity limits have become one of the central issues in this ongoing debate. Supporters of these restrictions argue they are reasonable safety measures intended to reduce the potential harm during violent incidents. Critics argue that limiting the size of magazines interferes with the operation of commonly owned firearms and therefore conflicts with constitutional protections. As more cases reach federal courts, judges must decide how these restrictions fit within the broader legal framework established by past Supreme Court rulings interpreting the Second Amendment. Although the recent ruling striking down the magazine ban is significant, the legal process is likely far from over. When a federal court declares a state law unconstitutional, the government involved usually has the option to challenge that decision in a higher court. In many cases, state officials quickly file an appeal, asking a federal appellate court to review the ruling and determine whether the lower court's reasoning was correct. During this stage, the appeals court may decide to temporarily pause the lower court's decision while the case is being considered, which means the law could remain in effect until the appeal is resolved. If the appellate court reviews the case, a panel of judges will analyze the legal arguments presented by both sides. They will examine whether the lower court properly applied constitutional principles and whether the law conflicts with protections under the Second Amendment. After reviewing written briefs and hearing oral arguments, the court will issue its own decision, either upholding the lower court ruling or reversing it. Even after the appellate court reaches a conclusion, the legal process may continue. The losing side can request that the case be reviewed by the full appellate court or petition the Supreme Court of the United States to take up the issue. The Supreme Court receives thousands of petitions each year but accepts only a small number of cases, usually those involving major constitutional questions or conflicts between lower courts. Because magazine capacity restrictions exist in multiple states and are currently being challenged in several lawsuits, many legal analysts believe the issue has a strong chance of eventually reaching the Supreme Court. If the justices decide to hear the case, their final ruling would establish a nationwide precedent. That decision could determine whether magazine bans are allowed under the Constitution or whether they violate the protections of the Second Amendment for years to come. If the Supreme Court takes up the case, it could become one of the most significant Second Amendment rulings in years. What do you think? Should magazine bans be constitutional, or do they violate the Second Amendment? Let us know your thoughts in the comments. And if you want more clear breakdowns of major legal rulings and breaking court decisions, make sure to subscribe and turn on notifications so you don't miss the next update.